Hi, welcome to week 3 of Recruitment Selection and Personnel Planning. Today we're going to review key concepts covered in Chapter 3. This chapter should be a review for you if you took Fundamentals of Human Resource Management. Read through the chapter and focus on understanding employment at will, contracts, and employment laws. I'm going to cover the major federal laws listed in Table 3-2 on page 55. This table is a summary of federal laws relevant to staffing, and you should review this information several times until you know the law, who is covered, the general provisions, and the website to locate more information. First, Title VII of the Civil Rights Act of 1964 requires all labor unions, employment agencies, educational institutions, local, state, and federal governments, and private employers with 15 or more employees to ensure there is no discrimination based on race, color, religion, sex, both men and women, or national origin. The Equal Employment Opportunity Commission, referred to as the EEOC, administers the regulations, investigates workplace claims of discrimination, and may provide legal services to alleged victims of workplace discrimination. This law was amended in 1991 to allow punitive damages and a jury trial. Pregnancy Discrimination Act of 1978 treats pregnancy like a disability and requires the same coverage as Title VII. Reasonable accommodations can be made by an employer as long as it does not cause an undue burden on them. The law falls under the EEOC. The American with Disabilities Act of 1990 provides the same coverage and protects those qualified individuals who are disabled or perceived to be disabled in all terms and conditions of employment. This was amended in 2008, requiring employers to consider a person without medication or other support and determine if they were disabled. Eyeglass or contact wearers are not considered disabled unless they are declared partially blind. This law falls under the EEOC. Age Discrimination Employment Act of 1963 protects those 40 years old or older in all terms and conditions of employment. The EEOC regulates this law. The Immigration Reform and Control Act of 1986 requires employers with 4 or more employees to verify a person is eligible to work in the United States. They use the I-9 form to ask for 2 forms of identification, and the Department of Homeland Security regulates this law. The Worker Adjustment and Retraining Notification Act, or WARN, of 1988 requires employers that have 100 or more employees to provide 60 days notice or 60 days pay when more than 50% of workers in a department or division or company are part of a layoff. The Department of Labor regulates this law. The Uniformed Services Employment and Reemployment Rights Act, or USERRA, of 1994 provides protection for military reserve and active duty. Employers are required to hold their job for 5 years or to pay them the difference between the military pay and the civilian pay. They also receive all promotions, benefits, and other perks that all employees receive. This law falls under the Department of Labor. Read through this chapter several times to ensure you understand all the employment laws and other legal terms that govern staffing. I hope this video has helped you with these key concepts for Chapter 3. Title VII, 1964, PDA, 1978, ADEA, 1990 and 2008, ADEA of 1967, IRCA of 1986, WARN of 1988, and USERRA of 1994.